So before I start, just give a little introduction. What legal due diligence is, why it needs to be done. So very simply put, what due diligence is, you check the facts, whether something, say for example, giving even the smallest example, say for example, you're buying a share of a company or you're buying a car or something, you'll always check as to whether it's feasible, whether it's actually the quality, the things that they are telling you, whether the facts they are stating is true or not, whether you're putting your money, is it going in the right place, whether that investment will help you in the future or not. So basically, legal due diligence is exactly the same. There's always an investor who's investing, not necessarily an investor, any person who's putting in money, he needs to know whether the money is going in the right place, whether the company or whether the entity rather says what they are is actually true, whether, so basically it's like an examination of facts, whether it's actually true or is there something more hidden, or is there something that could potentially affect our transaction. So that's what our due diligence is in the first place. Legal due diligence is just one aspect of it. There's multiple types of due diligences. One is related to your business due diligence, one is related to the tax due diligence, one is related to the financial due diligence. In tax, they check whether the tax liabilities or whatever the entity that they're investing in is right or not. Finance deals with the financial part. They even go into the turnover, the profits, the turnovers, the EBITDA, the profit after tax, whether the company's declared any dividends, how. So basically the finance part. The business part deals with the competition part, whether the company that they are investing into, whether they actually have the capacity to make it big, or what is the market size they can acquire and all of that. Legal due diligence is just one part, where it's just a part rather, I would say, which gives them the agreements that are made is based on the basis of the due diligence. If you all are aware of the agreements called shareholders agreement, share purchase agreement, or share subscription agreement, for those things, these are the things that are done in writing in that, where they actually find out whether everything the company is in order or not, or whether the facts the company is stating or not. Now, it need not necessarily be a company. It can be a LLP that a person is investing into. It can be a sole proprietorship into that, which is converted into a partnership form. It can be anything, but usually what we see, it's a company, not necessarily a company. With the startup and all the culture that has been going on so far, it can also be a it's usually a private company. Can be public companies, of course, but usually a private company. So that's where you probably start with the due diligence. So what happens is, I'll tell you, there is always two parties to a transaction. One is the buyer, one is the seller. The seller is the person who's selling out some part of maybe his whole company, some part of his company, whatever. The buyer is the person who's acquiring the entity. Just to keep this more simpler, it's usually in the form of shares. Just to give you the example, the seller is always a private limited company. Buyer is the person who's an investor. It can be any person, for that matter. So now what happens is, we as lawyers, what we do usually, so always we either represent the buyer or we represent the seller. Usually, in most cases, it's the buyer. I'll tell you, in cases when it's the seller, it's usually a person who comes and tells that, please evaluate and tell us the things that we are non-compliant with in terms legally. So of course, that's when you do a DD report again, and that's when you tell them that these are the potential non-compliances or non-compliance, or these things can be resolved, what cannot be resolved. If something cannot be resolved, what needs to be done next, so that they are in a good shape. They know probably when they're asking for a certain amount, so they are pitching something. They say when their company is worth $2 million or $10 million or whatever, they know they have the figure in mind, whether it's the correct figure or not. For buyers, usually they go through the documents, like I said. I mean, they ask the lawyers to do it for them, to see whether the company is actually correct and or actually appears to be in the correct position as what they are stating. Same thing, find out the non-compliances, and later on in the agreements, it gives them the right to negotiate. Basically, that's the underlying idea behind the legal due diligence, to negotiate the agreements. So what happens is, before I'll tell you what the actions that happens before the DD starts is usually the chapters that needs to be done. Then after that, there's usually a requisition list that goes out to the client, to the seller, where we ask for information. The seller has to comply with it and give all the requisitions, answer the questions basically. Then a checklist is made. This is in the form of a requisition only. And then you go ahead with the DD. Then a report is finalized, and that is shared with the clients. Based on the report, the client client takes a call whether the client wants to invest in the company or the client doesn't really want to invest in the company. Now, usually this DD, what happens, it's done into a chapter format, where every chapter, it tells you exactly what the underlying idea behind the chapter is it's divided into multiple chapters. So first is the corporate chapter, which deals with all the compliances or like related to the company law. Here we are taking the seller as a private company. I mean, whatever the corporate things are, essentially, I mean, the compliances related to the company. Besides that, there can be apart from that, there's a chapter called material contracts, where all the contracts the company has entered into before it being acquired, whether the contracts seem to be in place or not, the assets that the company has, the employment and labor, I mean, whether they are compliant with the labor laws, IP laws, intellectual property. Usually there can also be I mean, there can be times where the company is not into manufacturing or not like a normal company. It is an IP driven company. Say, for example, it has a software, which is what you're investing in. Say, for example, Meta, a company like Meta, if someone's investing in Meta, they're not exactly investing in the company, but they're investing in the intellectual properties that they hold. So it has multiple aspects to it. But here we'll take any normal company, any manufacturing company, and we can, I mean, it can be anything. But all the idea and everything is the same. The underlying chapters, the underlying thing that needs to be done is the same for all the companies. The first chapter is about the corporate information chapter. Here you have to basically find out what, like, first thing for the company, the main charter documents, that is the MOA and AOA, the financial statements, annual returns, the organization structure, whether that is correct or not. So those things you are supposed to see. In the financial statements, you usually also see the auditor's report. This is a little bit of company law, but every company needs to get its financial statements audited. An auditor is a CA, statutory auditor basically, and this auditor will always pass an opinion, say, or give a remark, whether it's favorable or not, or whether there was any restriction on the scope of his audit, which led to him qualifying his report. You have to look for those things in the audit report, whether he's qualified. You have to look for related party transactions. Related party transactions is basically, just to give you all an example, what happens here is the company and its director. I mean, companies have directors, that's very obvious. But say, for example, a company gets into the transaction with its director, whether that transaction is done correctly or not, or whether that transaction is done at an arm's length price or not. So arm's length price is essentially the idea. Say, for example, the company is buying a property. If it goes to the market and say the property is listed at 50 lakhs, same property, if the company is buying from the director, whether the director is charging more or charging less or charging what the market value is. So, for example, if the director is charging 50 lakhs, it's at arm's length. So there's nothing wrong with that. If it's not at arm's length, say, for example, the director is charging much more, the director sees this as an opportunity to make money, whether that's right or not. So those things are usually reported over there. They're reported in other documents also, even in the financial statements. But yeah, this is one thing, that a related party transaction, there's always chances of fraud, major frauds happening in these kind of transactions. So that thing needs to be evaluated. Besides that, you see the board composition of the company, the number of directors, the number of KMPs. Always, usually, if the company is planning to get listed later on, they have to have these designations given to the directors as whole-time directors, or non-executive directors, executive directors, independent directors. So those things, independent. So again, we have to see if someone is an independent. There's a little bit of company law, but you have to see whether the director, if the person is an independent director, is he having any pecuniary relationship with the company, he or his relative, whether he's holding any shares in the company or something like that. So the things that he's not supposed to do, and if something similar has happened, that's like a major red flag. And also to tell you about red flags, orange flag, green flag. So when you are making a DD report, essentially the whole idea is to find out the things that could, red flags are something that could be a deal breaker, essentially, whether the deal should go through or not if you find out any red flag. Orange flag is something that you can work on, it's workable. Green flag is something there's been a minor slight non-compliance, which probably nobody, the company also wouldn't be aware of. And just to, or the penalty for some non-compliance is very small, that these things can be rectified. So that's considered as a green flag, something like that. So that's how it's dead. That's how you classify the issues. Then coming back, so yeah, these are the chapters that these are the things you look at when you're doing for corporate. Now again, corporate is divided, the corporate information, it's divided into multiple parts. The second part being the records and compliances of the company. So all the statutory records, every company, they need to have certain documents. Say, for example, if the company has allotted some shares to its own members previously in the form of rights issue or bonus issue or preferential allotment or any manner, they need to have registers for allotment. They have the pass-3 form. They have their forms and everything in place, but they need to have that. Again, for those things, for doing those allotments, they need to take appropriate resolutions. That can be either board resolutions or special resolution or ordinary resolution. Shareholders resolution or board resolution, whatever that needs to be done. You need to check whether those resolutions are there or not. And that is something you get from the minutes of the meeting. And like I said, ROC filings, that are the forms like PAS-3. If the company is converted, say for example, from a private company, it became a public company, whether they file their form in INC 27, whether the minimum number of requirements, for example, the number of members, say for example, in a private company, you need 2 members, but in a public company, you need 7 members. So whether that requirement is fulfilled or not. Say for example, the company has any subsidiaries, so whether it's filing those forms and AOC4, including the consolidated financial statements, so those things need to be checked. These are basic records and compliances. Just to give you all a little idea, these usually most of the documents that you all need over here are available on MCA. Every company, when they are doing such kind of things, they have to make these filings on MCA. By doing the public search on MCA, you can extract all these documents. Something is not extracted, you can always ask the client, or you can ask the client to get back as to what has been done, what is not been done. Even with respect to the requisitions, like I earlier mentioned, what happens is you first ask for the requisitions. You ask everything from the client. You can do your own public search also side by side. If there's something that's missing from the public search records, you always get back to the client. You always make a requisition list part 2 or part 3 or part 4 and keep asking for the information that you require. There are times when this kind of thing also happens. Maybe the client might not have the information only. So again, that you have to flag it off and tell the person that you're representing that, okay, this information is not available, so we cannot review this part. So we have no idea. So you please take a call appropriately, like whatever you think is adequate. So that's the second chapter under corporate information. The third chapter is management. The directors of the company and the KMP. KMP stands for key managerial personnel. Then financial relationships, the power and the authority, and the board compliances. So first part dealing with DIR 12, the directors, sorry. So they have to file this form when they're appointed, when a person is appointed as a director of the company, they have to make the necessary filings. That is form DIR 12. And if they're KMP, whatever designation they've been given, if there's a company secretary also in the company, then those things. Then financial relationship, again, whether the director has any shares in the company, to what extent he has. Say, for example, a director of a company is also the member of the company and has around 51% shares of the company, more than 50% shares of the company. That means he can exercise control over the company, correct? So those things also need to be mentioned. Same thing like I previously mentioned. Say, for example, there's an independent director. So an independent director cannot have any shares in the company. So that part needs to be highlighted, needs to be checked with. The power and authority, that specifically when the company has directors who are categorized as independent directors or non-executive directors. To give you a little idea, non-executive directors are those directors who are not involved in the day-to-day operations of the company. Same with independent directors, they are not involved in the day-to-day affairs of the company. All they have to do is come for the board meetings. And that's when that's their whole thing. The directors who are the executive directors are the ones who are in charge of running the company. Then the board compliances, whether board compliances, for example, if you all are aware of a little bit of company law, then the board has to meet at least 4 times. There needs to be 4 board meetings held every year, somewhat similar to 1 per quarter, in the sense that between 2 board meetings, the number of days cannot exceed 120 days. So those things need to be checked with. Then you need to check whether all the directors have attended the meeting or not, or any leave of absence that was granted. Again, there are rules for that also, how many times you can do that. Say, for example, our director is not available. He has an alternate director in place. A person who's replacing him to act as a director. Also, you have to see whether the board meeting that was held, whether was it held physically or virtually. So if you're aware, when COVID-19 pandemic happened, they released with this information where the board meetings can be held virtually. Now that thing is still in practice, where a director can attend the meetings virtually. So those things also should be seen, should be marked. Also, to give a little bit extra information, there is a secretarial standard SS1, which talks about board meetings entirely. So that again is a compliance under companies law. That thing needs to be, like, a company needs to comply with that SS1 also. So those things need to be checked over here. So that's again the chapter related to the directors and the management. Next chapter is the shareholding chapter. This is usually a chapter where you have to see the shareholding of the company. What has changed is what is not. First share, when you start with the company, you start with the subscribers of the company. You get that information from the MOA and AOA, the people who are the first subscribers or the first people who own the shares of the company, what ratio, how much they own, and over a period of time, how their shareholding has been changed, what has happened, what has not happened, whether the company has diluted itself, whether there's been change in the authorized share capital. Authorized share capital is something that's like the maximum the company can issue, the maximum capital that a company can issue. So whether they are in compliance of that or not. Usually what happens is sometimes the company issues bonus shares. Bonus shares is where they give out shares essentially for free, or for, to put it legally, for consideration other than cash. What happens is sometimes the ratio is decided, everything is fine. But say, for example, the authorized share capital of the company is, say, for example, 1 lakh. The company already has 50,000 shares and it's issuing shares in the ratio of 2:1. That is 2 shares for every 1 share held. That means there's a chance that could immediately trigger this non-compliance, in the sense that the number of shares that they issue would exceed the authorized share capital. Again, that's a non-compliance. So that thing you need to check. You also need to check what transfers what transfers have happened, what allotments have been done, whether there's any private placement that was made, to who that was done. So that things usually comes under here. The documents that you need to review is the share transfer. If there's the company has entered into any private placement, then you obviously have to see the SPAs and the SHAs. If not, then you see the register of share transfers, the registers of allotments as to what is being done. Of course, there are ROC filings, like I said previously, forms like PAS3, SH4, those forms are always there. So these kind of things that needs to be done in this chapter, where you basically give an idea as to everything is correctly done or not, whether share transfers have been done. Even with share transfer, essentially, the company has to maintain a register of share transfer. One common mistake is usually when the transfer is happening, they don't pay stamp duty, or the share transfer forms are not adequately stamped. So that is also like a major red flag, because stamping is an essential, it's required by stamping needs to be done whenever there's transfer of shares that's happening. Then you also verify that with the register of members, whether the actual members you find out from the end of this chapter, are they corresponding with the actual members in the company register of members, whether there are any joint holders in the company, something like that. So that usually goes around in this chapter. Then the next part deals with the debt. So if someone knows a little bit about debt, there are 2 types of debt. That is, one is secured and one is unsecured debt. Unsecured borrowings and secured borrowings. Secured is something when you always say, for example, any person is going to a bank and asking for a loan. That loan, the bank will only sanction that loan when you give some security in return. Say, for example, I'm buying a house. I would have to give something as a security to the bank to make sure that I'll pay my loan off. In case I'm not able to, the bank will have the charge on my property. The bank obviously that it won't sanction the loan unless the person taking the loan gives a security. Same for companies. If they are getting a loan, usually there's a chance that most of it is secured. There can be some part of it which is also unsecured loans. This happens usually when, like I said previously, if a person is a member also of the company, also on the director of the company, usually he won't take any such security from the company, because at the end of the day, he's the one who's who's the one who's in charge and running the company. So that's a type of unsecured thing. But again, another aspect to this could be a related party transaction and arm's length price. So whether the director, so when in these things also specific. So first I'll talk about the unsecured part. In the unsecured part, you have to obviously review the loan agreements that the company has entered into when it's taking loans. Now, in these kind of loans, you have to see the rate of interest, whether it's the market rate, prevailing rate. Say, for example, some loan that was taken in 2014. So that time you have to see what the prevailing rate was. Based on that, you have to see whether it was at arm's length price or not. Today, obviously the things might change, the rate of interest might change. So these things have to be viewed accordingly to the back in the time, like what was the correct rate of interest prevailing at that time. Now coming to secured loans, there's always these forms called CHD1, which needs to be filed. Every time a secure charge is created, say for example, the company takes a loan. Of course, charges are also divided into 2 things. Fixed charge and floating charge. Fixed charge is something basically backed by an asset, which is not, I would say, which is immovable property. Say, for example, company wants to invest in plant and machinery. Probably they have their leasehold land. So they'll probably create a charge on that land, and that's how they'll get the loan. This is like a fixed charge. Say, for example, there's a floating charge. Floating charge is usually when the companies in, say, for example, manufacturing of bottles, or say, for example, manufacturing of cans or something like that. So those assets, the cans, they keep making new assets. So what happens? The charge gets crystallized in case the company is not able to pay their loan. Whatever the existing cans are, it's not any specific can. It's not a specific asset, but it's on multiple assets. Whatever cans the company is making, say, for example, the charge is created on that. Of course, these charges are also modified also over the years. The bank, say for example, the bank, usually what happens is the bank thinks that this person is not able to repay the loan, or he's repaid good amount of the loan. So they'll obviously change the terms and conditions. Say for example, a very big company is taking a loan from the bank. Usually they always make some amends in their agreements for those kind of companies, or they modify. So of course, for that also there's a procedure that's called modification of charge. So there are these kind of documents that you're supposed to see. Besides that, there is always, like I said, related parties. One important angle you have to see whether the company has taken any loans from its subsidiaries or given any loans to the subsidiaries. So those things come over here in this part, specifically dealing with the debt part. This is crucial because always the company in this case, what usually happens is when a company goes into insolvency, for example, always it's not the shareholders who are being paid first, it's always the people who the company owes. Say the people who are essentially the banks or anyone for that matter who's taken a debt from, there's some debt of the company that needs to be repaid first. So this chapter really needs to be focused and seen from that example. For finance, someone who's also doing financial due diligence, there is always a debt equity ratio that is set. Usually the market practice is 2:1. We as lawyers don't need to look into that, but specifically that's something we can also see whether the debt equity ratio of the company is correct or not, is adequate or not, rather. That also can be one aspect to it. We also over here, we see whether the company has made any defaults. What happens is if you make a default, say for example, this is a private company, tomorrow it wishes to get listed. There are certain conditions for a company getting listed for an IPO. The person who's in charge of the IPO, he cannot be a willful defaulter. The company cannot accept deposits if there's been any default in repaying its loans. So those things need to be taken care of. So specifically with that part, we have to highlight that and find out whether there are any issues in this or not related to charges. This is the whole idea of the the corporate chapters, corporate and the finance chapters, whatever that needs to be done. Again, now there's another chapter in this. Oh yeah, I'll discuss some issues as well. Usually the common issues that come up. So you're in the MOA, this is the charter of the agreement. There's always a capital clause in the MOA where they have to say what's the authorized share capital of the company. Or usually it even gives that the minimum paid up share capital of the company should be what, for example. And then the AOA, it's given usually. AOA is the document that it's basically the rules and the regulations of the company. If the AOA says that this should be the minimum paid up share capital of the company. But say, for example, over here, like in this case, the MOA states that this is which is quite less than what it actually is. Then there needs to be the amendment needs to be made in the MOA. That is the alteration. So this can be an issue that can be there. Then any amendment. Or also, just to tell you what happens is when we find out issues or when an issue is found out, three things needs to be done. First, the issue needs to be highlighted exactly what the issue is. The next thing you have to next thing you have to give a recommendation, like what needs to. The next thing is the penalty. You need to tell them how much penalty will it cost. Say for example, in Companies Act, always the penalties are given. If there's no penalty given, then there's a common general penalty that's also given. Say for example, a director will also be held liable in many of the cases. So you always tell the penalty. Then after that, you give a recommendation. Usually after this, when the next part is the shareholders agreement and all the agreements. In that, the company usually takes representations and warranties from the seller. The seller says that the company is doing fine or it's repaid all its loans and this and that, everything. Basically, it gives representations and warranties. Now you find out that there's some issue. So the representations and warranties are incorrect. So that's when you take an indemnity or a specific indemnity. Say, for example, something goes wrong over here or some non-compliance that you have identified. So you always back it by an indemnity saying that if tomorrow something comes into the light, me being the buyer shouldn't be responsible for this. I shouldn't be the one paying for this. So that's a specific indemnity that a company has to. This is how the issues are done. Again, they are classified into buckets, red, orange, green. Say, for example, an issue that doesn't have penalty at all, which just needs to be rectified or needs to be highlighted, that goes in the green bucket. The buyers, the person who's acquiring, they usually give us some targets. Say, for example, something up to 5 lakhs is fine. It's bearable. It's not a huge amount. It differs from every client to client. That's fine. So that comes in the orange bucket. Anything that exceeds that amount, that goes into the red bucket. Say, for example, places where there is imprisonment involved, of course, that will fall in the red bucket. So that's how the issues are classified. The next chapter is employment and labor. So usually you cannot see this chapter. This chapter is common, consistent throughout and all across. Whatever company that you're acquiring or whatever company whose due diligence is being done. So one of the most important chapters, and rather most of the discrepancies you will find is usually this chapter, because lots of rules and lots of regulations are there, and every company is, there's a good 99% chance, I would say, that no company is like will be entirely compliant with the labor laws. Say, for example, laws like Payment of Bonus Act, Payment of Gratuity Act, the Shops and Establishments Act. Here you have to specifically see in which areas the company is operating. Say, for example, it has one office in Mumbai, it has one office in Delhi, it has one office in Kolkata. So every state has a different Shops and Establishments Act. The rules and the holidays and the, say for example, the sick leaves and all those things. Everything differs from state to state. So you have to see the compliances from every state's perspective as to what is relevant, what is not relevant. Also, there can be a time where a company is located into, say, for example, a SEZ. That is like a special economic zone. So over here, there is always a relaxation that's given to many companies in certain SEZs where they don't have to comply with certain labor laws. ESIC, if the insurance, I mean the Employee State Insurance Act, those things are not applicable to certain SECs. So those things need to be also checked with whether a law specifically is applicable to a company or not. Say, for example, something like the POSH committee. Every company needs to, whenever the limit for that is 10, if the number of employees exceed 10, automatically there needs to be a POSH committee in place, a POSH policy in place, all those things. Always there's a chance, usually what comes up with, or usually the reason or the backing that people give, if, say, for example, they have the number of employees are more than 10, but say, for example, they say all of them are men. So there technically shouldn't be a POSH committee and all of that. So that's again incorrect because irrespective, it never really says whether the employees should be men or women. It clearly says if it exceeds 10, you need to have it. So those things need to be taken care of. Again, over here, you need to see the contracts also, specifically the contracts that the company is entering with the employees. So not just employees, even with the key KMPs, that is the directors and the key managerial personnel, whether the clauses in these contracts, specifically the clauses in these contracts, they are done, I mean, they are drafted correctly and are they strong or not, like watertight or not. Say, for example, a confidentiality clause. So every person who's engaged with the company needs to have a confidentiality clause that they won't really go out leaking the trade secrets of the company or this and that. Something like a non-compete, non-solicit for KMPs, they usually have these things incorporated because usually all of them shift and they usually end up helping a business that is in a similar field. Say, for example, they are in field of manufacturing perfumes. A person will just leave that company and just go hop on to the next company, and over there he'll give all the expertise and everything, the trade secrets, the name list of the clients and everything. So these clauses are always there, non-compete and non-solicit. So these needs to be reviewed. If not, if there's a chance that these such kind of clauses are not there, you need to tell the acquirer and tell them to make amends, maybe change the whole agreements or enter into agreements again. So that can be a big issue, specifically related to the employment and labor laws. And most of the, I would say most, like good amount of issues are found in this chapter, employment and labor. Okay, so there's this one issue that usually we come across is non-formulation of an equal opportunity policy. So basically the idea behind this is that a company always has to have this kind of a policy in place and they have to actually put it into practice also. So again, it's most generally many companies are not aware of this and they usually don't have one, or even if they have one, this is not put into practice. So then you state the non-compliance, the second paragraph over here, what the penalties can be, and then you give a recommendation as to what needs to be done. And sometimes in many cases, what happens in specific to labor laws, most of the issues are always can be settled and they really don't end up becoming big issues. So here always the idea is that you need to take an indemnity in case something happens later on. I'm backed by the buyer, rather is backed by an indemnity that he won't be held responsible for it. So that's the idea behind this. Okay, there's another issue that talks about the leaves. So always a company needs to have its leave policies. Say, for example, in Maharashtra, it's 12 and 12. A company has to, the minimum leaves should be 12 sick leaves and 12 casual leaves that needs to be given. Say, for example, a company is just giving 10 leaves in a day, in a year. So that is again incorrect. They're not compliant. Say, for example, if the company is giving 45 days. So again, always if you're giving something better, that's good and that needs to be complied with. So here you read the leave policy also and the act. And you need to see whether the leave policy and the act are correct. I mean, they are in line or not, or whether the leave policy is good enough or it's not going against the act. I mean, against what the law is stating. So that can be one issue. I mean, the next chapter in the legal due diligence is the contracts. And specifically, you won't go into all the contracts. You go into the contracts that are material to the business. Say, for example, a company has around 70% of its business from some government. Say, for example, the company is in Maharashtra. It has 70% of the business coming from the government of Maharashtra. But in the future, say for example, you see that the company, there's a chance of elections that's happening, and the current government is that might, the government might change, the party who's in power might change, for example. So obviously these things also need to be checked side by side, because the thing is, say for example, a company that's giving you 70% business, or say one entity that's giving you 70% of your business, if that gets changed, then there's a good chance you might not end up getting that business. So obviously the buyer over here will have a better right to negotiate his agreements. Say for example, the price that he's offering, he won't probably offer the same price. If some person is asking for $1 million, the buyer wouldn't probably, the buyer has the power to negotiate and bring it down, that okay, see, this is the situation, this is what can happen, now the whole valuation can change. So we need to see the material contracts. Usually what we do is we ask for the top 10 vendors and the top 10, the top 10 clients of the company and the top 10 vendors of the company. We review their agreements and how their agreements are. Say, for example, with their vendors or with their clients, there are certain agreements which have clauses like change of control. So right now, whenever a new party is coming in, or there is going to be a change of control or shift of power or change in management of the company, say, for example, the buyer that is coming will obviously have his representation on the board, or will nominate a director in his place to make sure the company is doing fine, because he's investing that kind of money. He'll all over here. So these clauses are there in agreements. When a company enters into agreements with their whatever clients or vendors or whatever, they have these kind of provisions. Say for example, a change in control. Whenever that change in control is happening, they always have these clauses that they have to take permission. Sometimes there's a chance these clauses are not there in a contract. So that means you don't have to take permission of the person if you're undergoing a change in your management. There's also a time, usually what happens is there's a point specific in a contract. Essentially, there's a part that talks about events of default. So sometimes what happens is under event of default and termination, you see where they say that any change of control will lead to termination. So in this case, either the company has one option where they have to let go of that client or vendor, or they have to renegotiate that with the current vendor and make them sign a new agreement, and that's how you need to proceed. That is one part of the material contract. Second thing is the related party contracts. Like I said previously, whatever the agreements the company is entering into with its related party, that needs to be checked first. First and the most important thing is rather, is it being done at arm's length price or not? How is it done? Whether the execution is correctly. Usually, what happens is when company sanctions loan to its, the company takes loans from its subsidiary, for example. We usually don't have these kind of agreements also. What happens is once we tell them, please provide us with an agreement, what is being done, then they probably draft an agreement. They formulate one, however they done, maybe make a backdate agreement or something. So those things need to be checked. But essentially, the major idea behind these related party agreements is that whether they are at arm's length price or not. If they are not at arm's length price, it's always an issue. And key clauses, like I mentioned, whatever the risk that like the events of default or the termination, in what circumstances can the person terminate an agreement. And sometimes over here we also have to see whether who has the right to terminate the agreement. Sometimes this right is unilateral. Essentially that means the company or the target does not have that right to terminate the agreement itself, or if they terminate, they have to pay a penalty, or how much notice. So those things also have to be seen. Then other contracts, these even include your NDAs and whatever. These are the basic requirements, whether the company has entered into such kind of non-disclosure agreements or not. This thing, because of course, once it's acquired by someone, or once a person invests, he needs to know whether what he's doing, what he's getting into, he needs to be sure of that. So those things, these are like basic things that needs to be reviewed. Then the next part is the assets of the company. Very specific. It can be really, it can differ from target to target as depending on the type of company that it is. Basic classification is movable property and immovable property. Again, there can be one classification of it as to being a tangible property and intangible property. Intangible property is something like, I would say, a patent or a copyright or something like that which a company has. Usually there are many companies. Say, for example, talk about a company like Zomato. It must have multiple patents, the trademarks and all of that. So all these are the major assets of the company. And the app itself, again, that is intangible asset. Then tangible asset would always mean your offices, your properties, plant and equipment, all those things. Same classification is done again, movable and immovable property. Immovable would be your land and building, plant and equipment. Movable could be, I think machinery is over here. Machinery usually falls under the immovable category. Movable could be your cars, your cars and other things that you use, your computers, laptops, all those things. So you're basically, you have to see the title documents, whether the title is clear or not. Say, for example, a company says that this land belongs to it, but whether the title is clear or not, that needs to be seen. The agreements that the company has made, or say, for example, company has bought a building, or a company has this plant and machinery in their name. So you have to see the title documents, whether the title of that thing is specifically relating to the company or not. What usually say, like I mentioned, intellectual property. What happens is usually when that intellectual property is created, how it happens is it's usually created at a very nascent stage. So what happens is the person and individual, not the company, but the individual creating it has it in his name. And later on, there's an agreement between the company and the individual where the individual assigns these intellectual property to the company so that they can use it. So that needs to be checked. So whether actually, if say for example, you're investing into a company where there's IP is involved, a good part of it is intellectual property, but that intellectual property technically doesn't really belong to the company. Then what? And then you have to see the agreement specifically if there's an assignment that's been done. In case those agreements have some provision where if there is some change in control or if there's some change in management, you need to take the consent of the person who's assigning it. Even that can be an issue, because unless and until you don't get the consent of the person, how can you put your money in? Like technically, if you're going for a property that's in, I mean, if you're buying a company specific to IP, intellectual property, so those things need to be taken care of over here. Sometimes, I mean, that's majorly about assets. I'm not going more deeper into this, so sorry, but yeah, this is our next part is dealing with the insurance. This is one of the most important points. Say for example, every company that usually functions, say for example a manufacturing unit or something, they need to have these policies in place, because tomorrow there's always a chance of fire, there's always a chance of some natural disaster, there's always chance of some natural calamity or theft or anything, fire, like I said. So what happens is that would result in, I mean, the whole, if say for example a whole industrial unit is burned down, or there's some big theft that has happened, so there's always needs to be some insurance to protect. Say for example, a person invests in a company having no insurance, and turns out the very next day there's been some big theft in the company. So where will he go? Like that would be unfair to the buyer, correct? So these things really need to be checked with. Say for example, the next part is statutory insurances. If any statute specifically requires some law that specifically requires, say, a company X who's into this sector to have a specific insurance related to that, then those things need to be checked. Again, that's where we as lawyers majorly have to see whether company, say for example, dealing in alcohol or something, whether they have a fire license or not, because it's an inflammable product. Say a petrol pump over there, whether even they have fire insurances or not, because the idea is that this could result into huge losses to the company. And besides that, you also see the claims, whether there have been any claims made by the company, whether they've been processed or not, how much they've been given, with which companies or with which insurance agencies they have these kind of claims. So those things need to be checked over here. The next is about the permits, licenses, and approvals. Again, this is a very important from a DD perspective, in the sense all the permits, all the necessary things that you need to carry out your business, whether those permits and licenses are there in place or not. Say, for example, again, it's a manufacturing company, whether it has a manufacturing license or not. What happens in these manufacturing companies also, they hire contractual. It's usually not everything is done by their own employees. They have contractors who then provide them with the labor, the adequate labor. So whether a person who's providing a contract, the laborers, whether that person also has a contract labor license. So those things you need to check. Besides that, any other licenses, whatever the requirements under law, even our normal shops and establishments license, whether it's registered or not, those basic things, even all those permits, licenses, everything needs to be checked. We even have to check the expiry dates in these. And like, say for example, if something is, as soon as the transaction gets over, what happens in a transaction is there's always a closing date that is set. Say for example, 30th April is the closing date that is set. If you find out some license is being expired on, say for example, 2nd May, so over here the license is still in place. But what happens is you need to tell the company that, see, this is going to expire. I mean, you need to tell the buyer essentially that, see, this is going to expire pretty soon, so you better make sure that the company applies for the new license. Or say for example, a company doesn't have a license, if they are non-compliant, so you can always add that as a point to make sure that the company at least applies for the license. What happens is there can be a period of 30 days, there can be a period of 60 days, which can be before the closing also, which can be after the closing date also. So always you need to make sure and tell them that, say, okay, so say for example, the closing date is 30th April, like I said. Today is 1st April. If I make an application, it minimum take me 60 days to get my application done, me getting done with the application. So as a condition precedent, one thing I can say that, okay, at least they have to file for that application and make that application. Say for example, you get something in 15 days. Then you have to make it as a thing that, no, this thing needs to be done. This license needs to be obtained. Then only the deal will go through. So those things are important. Say, for example, like I said, you're operating in SEZ or something like that. So do you have the necessary permissions from the authorities or not? So those documents need to be checked with. So that's another chapter in the dealing with the permits, licenses, and approvals. The next part is environmental laws. Again, so now again it differs from company to company whether these laws are even applicable to the company or not applicable to the company. Say for example, it's a manufacturing unit. They have these. There are lots of, and I mean, there's Environment Act in place. Whether the waste that they're treating, are they treating it correctly or not? Whether they have the required licenses or not, the certifications or not. Also in the environment, usually what happens is always a pollution control board. Say for example, air pollution control board or water pollution control board. Whether the registrations are there or not, and whether these companies are actually they're compliant with the environmental laws or not. Is always a big aspect, usually overlooked in DDs, but again, as always, it's important. This forms one chapter for dealing with environment specifically. The next chapter is litigation, not exactly litigation, but something dealing with the disputes. So in litigation, also two aspects: the number of cases that a company has ongoing on it. Say for example, it's a small company, but has it's a good company. All the financials and everything is nice, good valuation. But say for example, it has lawsuits, multiple suits over it, all dealing in a big number, almost say for example 25% of the value of the company. Then it's always a red flag that you need to tell. You need always the what happens is here we pull out the orders from the court, from the e-courts website, and then we summarize the case law and say whose favor was it ruled in, what order has been passed, whether this case is still into litigation or not, who all are accused, what are they accused of. What happens over here is also the directors of the company, the management essentially. You see if there's been a case which is accusing a person of, say for example, some not necessarily a non-compliance, but of some crimes, any crime that could be, so that needs to also be flagged off. Say for example, there's a posh case that's going on against one of the directors of the company who's acted incorrectly, or some case of fraud that has been going on, he's done some fraud in the past or something. So these things needs to be highlighted, because this is like these can be the deal makers or the deal breakers specifically with litigation. Other aspect to it is arbitration, whether number of arbitrations that the company is going into, whether there's been any award that has been passed or not, or any chance or good chance whether it's going to be passed in there. So these things always usually help the client to negotiate better the terms of the the valuation and the terms of him investing in the business. So this is a chapter that's specifically related to litigation, but a very important chapter. If there is a chance that, or there's a, say for example, right now the Lodha disputes that's going on between the brothers over the trademark. Again, Lodha itself is a big name. Whoever, say for example, in the similar situation, say for example, if you're in a company that all doesn't really have a trademark in its name, and there's some big litigation that's going on, there's a good chance the goodwill that the trademark has created will eventually lose its power. So again, you'll have to restart from the scratch. So that again, those things specifically are covered in this chapter, where this is more like a reporting chapter where you tell them whether this is right or wrong, or whether this can be a potential threat or not in the future. So that part deals with the litigation aspect. Then there is obviously IP, all the IPs, the domains, the patents, copyrights, trademarks that the company owns. Here we also find whether the company has applied for any copyright, the company has applied for any trademark. Say for example, it has a website, whether the website is owned by the company or not, whether they are really, all the documentation, the registration, all that is in name of the company or not. If there's any person having a similar trademark, then that needs to be told to the company. Here it's more about also doing independent search, whether what exactly is the intellectual property of the company. This can change from the target specifically. Say for example, a company is into IP, majorly into IP only. Say a company is into making movies, so whether they have the adequate copyrights or not. So it depends usually from the target as to what chapter will be more important and where should it be placed. But just generally speaking, this is how the DD report flows like. So yeah, that is with the intellectual property rights. Again, like I mentioned previously, you have to see the assignment also, whether the company has entered into any contracts where they are assigning their IP, anything for that matter. Any technology, any specific technology also that the company owns. If the company owns, whether it's just they have a patent for it or not. Those things are all done over here. Any claims and disputes also, it again forms a part of litigation, but over here also you are supposed to, it forms a part of this chapter as well. So these are some of the issues. Say for example, okay, this is talking about registration of trademarks. But if there's always a chance of a trademark is not being registered or incorrectly registered or something like that, that can always be an issue, whether it's authentic or not. One aspect is also dealing with the part of FEMA, the foreign investment, whether the company has made any overseas investment, or whether it has received any investment. So for that, again, there are these forms and FEMA compliances. Sometimes what happens is if the company has, say, for example, recently there was a circular that was out, like India specifically, all the companies in India, they cannot have really, if any investment is made from countries neighboring it, say, for example, China or Pakistan or some countries like that. So they need to obtain the permission of RBI, the central government, and those things, and then only they can proceed with such kind of transactions. So those things specifically, they come in this part. Not every company will have foreign investment. So it's again very subjective. It depends from the target to target whether they have it or not. So the FEMA compliance needs to be checked. So yeah, these are essentially the things dealing in the what happens in while doing a legal due diligence. Steps after this is making the, not always necessarily the same person will be doing it, but the steps after this is the client takes the call whether they want to proceed with the transaction or not. Then the transaction documents are made, that is the shareholders agreement, the share subscription agreement. Here all the negotiations that happen are being done, the prices are negotiated. The indemnity, specifically the indemnities part, is a crucial point over here. What happens is whatever indemnities you've taken, whatever the potential non-compliances that you found out in the while doing the DD, the client will always make sure that it gets indemnities for those things. Again, in that, it depends from client to client as to how much, what can be a limit. Say, for example, they say anything up to rupees 10,000 is fine. If some non-compliance happens, but up to rupees to 10,000, that is fine with it. But say something that exceeds 5 lakhs, that wouldn't be a good, I mean, something like that, then that needs to be always covered. So these clauses are argued basis the due diligence report. So that's why it's the most crucial and one of the most essential things. Of course, this is all the main agreement that's going to happen is done from it's derived, rather, all the things that are incorporated in the agreement are derived from the due diligence report, the legal due diligence report. So that's how we proceed with whenever a transaction is happening. This is like the first step to a transaction. So this is about it.
So, Devansh, there's a query. What is the key difference between the process of an audit and due diligence?
Audit, okay, good question. What happens is audit needs to be done every year. It's done by a statutory auditor, and that statutory auditor needs to be a practicing CA. And he reports whether the statements of the accounts, like basically the balance sheet that the company is making, whether it gives a true and a fair view of the finances of the company. The whole point is not to find out any details, but it majorly gives it's like expressing an opinion saying whether the company is fine or not, specifically to the financial part. On the other hand, the second part is you're talking about the due diligence, correct? Here we are not involved in the technicalities of the finance because we already have someone who's reported on that. Here we are more concerned about the non-compliances, the things that can be missed by an auditor. Say, for example, the filings part, or whether they've been correctly done or not, or there are, say, for example, a form that is, for example, pass three, whether it's done in the right time frame or not. The audit, see a person, say, for example, the company has issued some shares in the form of an allotment, and whether it has received the money. So that part will probably be taken care of by the auditor. But whether the company has made the adequate filings, whether the company has done the right procedure, or the resolution that it needs to be required, whether the same thing has been incorporated in the minutes or not, that is not something the auditor will do. That is something what happens in the due diligence, and that's where we come into play and where we tell them whether it's correct or not. So that's the major difference. And again, audit can only be done by a practicing CA, and that practicing CA can only, person, and it can be an individual or a firm also. And again, for that auditor also, there are certain things. For example, if it's an individual, only he can be there for a maximum term of 5 years, and then in case of a firm, or 2 terms of 5 years each. So this thing needs to, it keeps changing every year. The financial statements are being audited. That gives that gives the company the idea whether the things are in place or not specific, but majorly about the financial part. Due diligence is a little bit different in the sense it not just only reports on finances, but everything else. Whether the procedures that are actually supposed to be done as per law, as per the articles of the company, have they been followed or not, like those things.
Okay. The next question, what is the average time frame of a due diligence process?
Actually, that depends on the client and how, like, the clients, the closing date, whether, like, what can go up to a month, also can go up to more than that also. If you're talking about the time frame as to how much, for how many years the due diligence needs to be done, then that is usually, if it's a M&A merger, if it's an acquisition transaction, it's past three financial years of the company. And if this say for example a transaction is starting in December and might go up to March, But then the three, I mean, if you look at the prior 3 financial years, that would be a big time frame from, say, for example, April to September. So in that case, always a little, the remaining part is also done with unaudited financial statements also and other things. But yeah, it's usually in that case, it's done for 3 years. And if it's a merger or something like that, then you have to go from the start. Then it depends how it depends from law firm to law firm. It depends from how exactly it needs to be done. Usually everything, right from incorporation of the company, everything needs to be done. The time frame actually required for doing a DD can even go up to 1 month, can go beyond a month. So it's with the clients, the discussions when they want to close the deal and what is the cutoff date that they've given to take a call. So that's how it's done.
Okay. The next question, are there any courses in due diligence that you can recommend?
Courses and due diligence, none that I'm aware of, but there are a few. I mean, for due diligences, I don't think there are any courses as such specifically. It's more like a practice. I mean, I'm not aware of any courses as such. But majorly, if you I mean, you have to be specific to the part in what sector rather you are doing the due diligence. Say, for example, you're doing something into labor, then you need to know the labor laws and the state in which it's operating, the entity that's operating, the laws applicable. So something when you are dealing with the corporate chapters, it's usually the company's law, the company's act, company's rules. Say, for example, the foreign investment is involved, and FEMA obviously is important. So it's more like, even besides doing a course or something, I think it's even with the law and brushing up of the law, that's like more important when it comes to a DD. The rather also the entity, what kind of business the entity or the target is involved, what laws would be applicable. Say, for example, someone is into manufacturing of cars. What laws would be applicable for that? Someone is into some model like Zomato. What specific laws would be applicable to them? It differs from the entity or the target.
Okay. The next question is, can due diligence involve interviewing the stakeholders?
At time this was a practice back in the day. Now everything is available on, like, all the things are available on MCA. Interview, I'm not sure whether it actually happens. I mean, if you are representing the buyer, certain questions, if you have to ask the seller, yeah, you can always ask the sellers. Everything doesn't, I mean, it's not like everything goes on record or whatever the person is saying or the person is claiming. I mean, you can have conversations and all that with the seller also if you want to seek more clarity. When you send out the request, usually it's in the form of the requisition list. Whatever questions you have, you usually ask, and you always wait for the response. And because it's always in writing, it's always better. Interview as such, I mean, I have not come across anything specific as where you're interviewing the person. It used to be back in the day.
Okay. The next question, can a due diligence report be challenged?
Oh, that's a very tough question to answer. It's always whenever a person who's making, I mean, the entity, the firm that is making a due diligence report, they usually make it a point to have the names of whatever, I mean, at least list that. If they usually, they might have a copy with the permission of the client. Sometimes what happens is even the trade secrets are involved. So the clients usually ask them to delete the copies of the trade secrets and everything, or the entire whatever documents that they've received. In this case, at least the client, what happens is over here, practically speaking, the firm who's doing it, they have a note of all the documents that they've reviewed, and usually a summary of them, ki what things were there in the document. So sometimes later on, if something happens and something goes wrong and something is challenged, they always have a backup. Okay, this was reviewed and this was there and this was not there. So it depends usually on the information, what exactly is there and what exactly is not there. I mean, always there is a scope of a DD also, that's always in the start of a DD report, where you say it's done on the basis of the information that was available or made available to us. Beyond the scope, we cannot take any such liability. So yeah, that's how it's done practically.
Okay. Devansh, a participant is asking, today we are discussing legal due diligence. What are the different types of due diligence?
So, like I mentioned at the start, one is dealing with financial part. People who've done done their CFAs and all that, CAs and all that. They are usually the ones who are into financial due diligence. That's where they report on the annual growth, the turnover rates, the ratios, the financial ratios, debt equity ratio, earnings yield ratio, all these ratios. So that's where usually when a person invests in the company, they just don't want to see whether the company is legally fine, but they are more interested in the financial part, wherein they specifically deal with what is the future of the company. Say, for example, they are having a turnover of 2 CR today. What is their turnover going to be what is their projected turnover after 2 years? What is the size of the industry? So those ratios over there, they really matter. So that's financial due diligence. And there's something called as tax due diligence, where all the GST returns and everything. So as lawyers, as legal due diligence, I mean, if there's a specific tax team who does that, then that is usually done, or else it's usually outsourced and some person specific dealing in tax. Some CAs, they are usually the ones who do the tax due diligence. whether the company's filing is returns or not, the GST returns, there's that whatever liability, input tax credit, whatever is there. Besides that, there is, like I said, legal due diligence. Besides that, there's like even a competition due diligence. So all the people who call, like in when someone is a management consultant, one aspect of their work is also competition due diligence, where they see what is the size of the market and whether there's competition or not, or who can be the potential threat. That threat can also be an opportunity. Say, for example, you are into the if you're a small company, say, just giving a right example only. Say, for example, you are into manufacturing of cars. You will have multiple other people competing with your business, and not just say, for example, you just started out, but there are multiple other people who are already there, players other who are already there. So that part of it. So all that can, even from that angle they do it, whether that can be seen as an opportunity or a threat. Say, for example, 2 years, 3 years, you make a good product, you develop some technology which can be useful to, say, for example, Mercedes. So there's a good chance Mercedes might acquire you or get merged with you or whatever. So those things they do. So those are the different types of due diligences. There can be more. Environmental due diligence is done. So social due diligence is done. Those things are there. These are all new concepts. So, but yeah, these are the majorly the types. Financial, tax, and legal are the majorly the three types of due diligence that are done.
Okay. Any book recommendations?
So of course, your Bear Acts would be really important. If you are doing something related to Companies Act, then there are on CS webs. I mean the ICSI website that is for the CS. They have these knowledge portals where they are academic portals where they have information on specifically like the whole procedure for, say, for example, if you are looking into rights issue of a company, they have the whole procedure listed down over there. So those things you read and you could get an idea as to the number of days of filings, whether things are in place or not. So yeah, of course, your law is very important. These books are also equally important. And besides that, if you can have access to some due diligence reports also, if you work wherever you are working or something like that, you can always have a look as to what. I mean, by reading the due diligence report itself, you get an idea as to what potentially could go wrong or what mistakes were initially found out. To give a small example, if you are aware of, balance sheet of a company, say, for example, an expense is shown in a company stating that professional and legal expenses are two statutory auditors. So now the thing is that the statutory auditor is only entitled to the fees. I mean, the statutory audit fees. What happens over here is there's a section 144 in Companies Act which states certain services an auditor cannot give to a company, because then the auditor wouldn't be independent, or the opinion that he's expressing on the financial statements would be incorrect. There's a good chance of that. So when you say legal, that is fine, that is allowed. But then you say professional. So there are certain, say, for example, the auditor is given management consultancy services. That's like a major red flag, because then the opinion that the auditor is expressing is incorrect. So those kind of issues. So that's why I think that develops on the number of DDs that you do, the DDs that you read, the past DDs that you read. And besides that, it's just the knowledge of the law that you have. So you need to be really good with that in that aspect specifically, so you can point out.
How frequently do organizations opt for due diligence?
Or whenever, I think it's a requirement. So whenever you are doing these kind of transactions and M&A transactions, it's like a given that these due diligence needs to be done. What extent and how, that's always dependent from target to target and from client to client. But yeah, it's always a due diligence is done. If the person is putting money, and we're not talking about little money, like we're talking about specifically companies, major companies or startups or something like that. So any person putting their money, taking a big stake and all of that would make it a point to have DDs done to find out what's the actual position of the company. So it's done very now, at least now the trend is very frequent because M&A itself is rising in India itself. So yeah, lots of foreign investment coming in and this and that.
Okay. So, Devansh, we are done with the questions.
Okay.
Can we conclude?
Yeah, sure.
So, Devansh, thank you so much. It was a very engaging and a very interesting session. There was so much that we learned from your session today.
Thank
So,
you.
thank you so much for giving us a basic understanding of the process of legal due diligence.
Thank you. Thank you so much.